I want to welcome everyone to the second in our series of webinars on small business succession planning. Pleased to have you all here. Today's speaker is Jim Awesome. He's with the firm Weston Hurd up in Cleveland. He's one of the best estate and succession planning lawyers we have in Northeast Ohio. Jim's going to be talking about the ABCs of succession planning, a practical approach to achieve a workable plan. It's a good intro section. It covers the range of beginning issues that business owners need to take care of when they're starting the succession planning process, the issues they need to concern themselves with. And at this point, I want to let everyone know that we have the chat feature. If you want to send a chat, just click on point your mouse to the chat window, type in a message, send it off, and both Jim and myself will get it if you have questions. If you want to raise your hand, on the left-hand side of your screen, you'll see a little button that says raise your hand. And at that point, we can open you up to ask a question. And we will also be opening up the phone lines to everybody at various points during the webinar to get kind of a round-robin questions going if we have any. So I think without further ado, I'm going to turn it over right to Jim.
Good morning, everyone. I've done a few of these in terms of webinars, but I've never done one for the Ohio Employee Ownership Center, so this is a privilege. We have what appears to be a reasonably tight-knit group, so my preference is to answer questions as they arise to you, because that's a more effective method I have found instead of waiting till the end. So if raise your hand or send a chat message, we'll do it that way. My job is simply to communicate effectively for the next 45 minutes or so. And I'm not going to give you a technical discussion of succession planning in terms of things like intentionally defective trust and grantor retained annuity trust and Section 2703 of the Internal Revenue Code, etc. Because all of those things are, although integral parts of succession planning, you can't get to until you find out what the client really needs, what motivates them, what this business is about, and get a practical plan in place. So that's how we're going to address it this morning. I think it works. I've been using it now I've been doing this for 33 years. I've probably been doing succession planning for approximately 20. And I've used this method. I have not copyrighted it, so you are welcome to use it if there are professional advisors on the webinar. But it's something that I have found very, very effective. The first one is, let's go to step 2 here, which I consider the necessary step 1 is the 3 W's. Now, the 3 W's, and I use these to help clients remember these things, and they remember them quite effectively, I have found. And the first one is, what does the senior generation, which is obviously the current ownership, require from the business on a going forward basis? And this is something that you must begin with, because if the individual owners or multiple owners put away a lot of money, perhaps they don't need anything. And so then we're talking about what the issues are related to perhaps gifting their assets to the next generation and avoiding any gift tax implications or minimizing gift tax implications and minimizing estate taxes. If they are like most of my clients, they probably require a great deal of money from their existing organization because that's all they've had. And that's step 2. That's the breakout of the first W. How much cash does the senior generation require from the enterprise on a going forward basis? Do they need 6 figures plus? Do they need health insurance? Many of our clients are selling their businesses now in their 50s or their early 60s, and unless there is some accommodation made for health insurance, there's going to be a gap between the time they dispose of their business and the time they go on Medicare. And depending on how their health insurance policies are written, they may need to continue to be some kind of common law employee or have some contractual arrangement with the entity to assure themselves that they're going to have health insurance. Most of them have their automobile run through their company. And in a lot of cases, they need something to do, and they've been very successful in their family life, their personal life. Their being, if you will, has been their business. So if they sell the business, whether it be to family or an outside unrelated party, they need something to do. What are they going to do with that business or their life on a going forward basis? Now, one of the things that I stress when I talk to clients about this is that you need to be realistic, or your clients need to be realistic as to what they really require from their company going forward. If they've owned the company for 25 years, for example, it's probably been 25 years since they bought gas for any of their family automobiles or company cars with anything other than the company's credit card. It's probably been a long time since they paid for a meal out to dinner, etc., without it going through the company in some fashion. It's probably been a long time since a vacation was not a convention or a director's meeting or something like that. The point I'm making is that clients often forget how much of their personal lifestyle has been provided by the entity. So when you're dealing with this first W, what does the senior generation require? It is essential that they are realistic and their accountants are realistic as to how much money they are literally taking out of the business. Now, the last one on this slide, very little. If the owners have been fortunate enough to acquire significant wealth outside of the family enterprise through qualified plan, investing in real estate, who knows what, then again we're talking only about tax and legal aspects. We're not talking about the practical, how much cash needs to come out of this business to really provide for the initial generation. But that step one is a way to kick this thing off. And the accountants, the bookkeepers, the spouse, the people that know how much money that the owners are spending can be very helpful in putting step one together. The next one is, what can the business afford? Obviously, you have to marry the first step, what does the senior generation require, with the second step, because if the business can't afford to maintain the lifestyle of the senior generation and still grow and still be maintained as a viable economic entity, to be a problem, and we need to address those problems on a realistic basis. In addition, I've almost invariably found that the second generation, if you will, whether it be management unrelated to the ownership or the next generation of the family, they want to make more money too. And I tell the second generation, don't expect your parents to take less so that you can make more. They may not take more from the enterprise, but generally they don't take less for quite some time. And so the ultimate decision is that the business probably needs to expand in order to have the succession plan be successful. Now, one of the things to think about here is, what is going to be the tax implications and the reality of this plan? The business itself must remain healthy. It must have capital expenditures. It must have operating cash flow. It must provide for the employment of various family members, etc. The old story is quite common. When mom and dad owned the family enterprise, they were supporting one nuclear family from that family enterprise. As their children grew up and became members of the organization, had families of their own, now this family business is supporting multiple owners. So there may be issues that really address a difficulty of expanding the business to allow the individuals to really grow. It's what I call the practical side of the succession. In other words, you have to grow the pie, or the successors are simply going to be dealing with the issues of smaller and smaller slices. So you have to expand the business in some fashion to allow the successors to live the lifestyle that they want to live, etc. So part of step two in this 3 W's is a business plan that will allow the organization to flourish, because if the organization fails, the succession plan will fail, the senior generation won't derive what they need from the enterprise, and obviously then the second generation will fail as well. And one of the things that I stress in doing this kind of planning, because an awful lot of people take the position that there's very little risk in a family enterprise, that if you're part of a family enterprise, you are blessed, because you don't really have to go out and start the organization yourself, etc. However, I've had a couple of clients who were in family enterprises that failed, or they were in family enterprises, and because they couldn't get along with their siblings or their father-in-law or otherwise, they're no longer a part of the family organization. Now, when you're 45 years old and your resume says fired from the family organization, that is not exactly a door opener in terms of finding new employment. So it may be a position where the individual has to have saved a few dollars so they can find their way in terms of acquiring another company. So there's plenty of risk associated with family enterprises that sometimes people simply don't take into account. The next one of the 3 W's is, what is the business worth? Or perhaps a subtitle is, what is fair? What is fair in the context of the members of the family who've been in the enterprise and the members of the family who are not in the enterprise. For example, if the business is worth $4 or $5 million, as determined by a legitimate valuation made by a qualified valuation expert with the appropriate initials required under the Internal Revenue Code now, and the senior generation, after you've gone through the first W, determines that they only need $2.5 million. That's great, because you have a $5 million enterprise. Then the senior generation only needs $2.5 million to provide them with the first W for their lifestyle, etc. Unfortunately, you have to be very careful in planning, because under Section 2703 of the Internal Revenue Code, the Internal Revenue Service presumes that all transactions between related parties or the natural objects of one's bounty probably have some form of gift element to them. And with that form of gift element, then there may be a situation where the individual will have to pay gift taxes. Now, who's the individual who's going to have to pay gift taxes? The individual who's going to have to pay gift taxes is, of course, the grantor of the gift. And that grantor of the gift is going to have to go ahead and pay gift taxes on the difference between the sale price, in my example, $2.5 million, and the actual valuation of the organization. So $2.5 million gift at 45% can be very ugly. And of course, the grantor, the owner of the company, is the one who has to pay that gift. So if they're receiving $2.5 million for the sale of their company to the next generation, but they have to pay 45% in taxes on the gift tax element, it doesn't give them enough cash to meet the first W. So clearly, you have to be careful in your planning to make sure you take into account what is, in fact, the gift tax or estate tax or even income tax ramifications of your transaction once you have determined its value. The trouble with closely held businesses, no one really knows what the value is until the entity is sold to an unrelated third party. But in order to comply with the Internal Revenue Service's provisions, you must, in fact, go ahead and make sure that you are doing it with a qualified appraisal from a qualified expert to make sure that works. Now, let's go on to the next part, the subpart of what I call what's it worth. Let's say the individual started the company, the father, 30 years ago. 25 years ago, his son or daughter came into the business. And he's one of 3 children, only one, though, however, that is actually working in the family enterprise. When this family enterprise, 25 years after the second generation has joined the enterprise, is going to be passed on, how are we fair to both generations? Should the individual who was part of the enterprise for the past 25 years get some form of sweat equity? For example, it would be ideal if you knew that the business was worth $1 million 25 years ago when the son or daughter joined the enterprise, but then, in fact, 25 years later, the enterprise is worth $5 million. Now, has that son or daughter contributed to the creation of that additional $4 million of value? And if they have, do they get some form of credit in the succession planning process in determining what the senior generation needs and what the business can afford for the value they have created? It's counterintuitive, of course, in the sense that the more successful the enterprise is, the more expensive it becomes for the member of the family who's involved in the enterprise to buy out his or her parents as well as potentially their siblings for estate planning purposes. So you have to address what is reasonable. One of the techniques we often use is we go ahead and use an estate plan that determines that the enterprise itself is going to go to the members of the family who are participating in the business. And we're going to go ahead and say, in my example, for instance, that that enterprise is worth $5 million. So we're going to go ahead and provide that the other siblings who are not in the business are going to get the other non-business assets to the extent of perhaps $4 million, giving some form of sweat equity credit to the the second generation that is actually participating in the business. Then, if there's sufficient assets to allow the business to go to the individual. There's a question here from Roy Beam. How do you obtain a listing of qualified appraisers that can give a worth for a business? I would talk to the attorneys or CPAs. In a town like Cleveland, for example, where I practice, there is a plethora of qualified experts who do just this kind of work. And they work with the attorneys and the CPAs as well as investment bankers in town on a regular basis. You can also talk to investment bankers. Quite often they do their own valuations, and they generally have the correct initials after their name so that when a gift tax return is filed and you are required to disclose on the gift tax return to the Internal Revenue Service how the valuation was arrived at, what discounts were taken, etc., basically what the Internal Revenue Service is saying, you must attach that valuation expert's report to your gift tax return. So word of mouth is probably the best way to get them a list of qualified appraisers. And for example, in this town, it would be very easy to give an individual 3 qualified appraisers who have done tax court work, who have done closely held business work, etc.
Jim, quick.
Yes.
I would second that. Word of mouth. Find someone who is recommended by someone you trust is a good way that we put it. One of the other things is that we at the Ohio Employee Ownership Center maintain a list of service providers on our website, and among those are a bunch of folks who do valuations as well. So you can get I don't know how many are on there, but my guess there's probably 10, 12, 15 folks on there in different geographic areas around the state and around the country. And that's a good way to find out. And I would not be afraid to interview more than one. Find someone who you enjoy working with too. So, all right, that was it.
Chris, I am for whatever reason I don't seem to be able to use the thumbnail. So for whatever that's worth, okay, they don't seem to be allowing me to highlight things and move around. So
okay.
So we'll just keep muddling through here, but
okay.
It doesn't seem to be working for me right this moment. So what I say then is, don't provide members of a family who are not active in the family enterprise with ownership interest. That's somewhat of a radical statement for someone who does estate planning as well as succession planning. But the problem is non-active, non-contributing members of a family who end up owning a piece of the family enterprise usually leads to acrimony. Depending on how the family enterprise is structured, particularly if it's a C corporation, the C corporations don't pay dividends, and S corporations don't like to pay significant distributions, by my experience, to non-contributing members of the organization, of the family. So it may be good estate planning to spread out the ownership among numerous family members, but it can be very disastrous succession practical business planning because you are setting up a situation where there will be family acrimony. So we try to give the non-involved family members an interest in something other than the enterprise. A very easy and effective way to do that is with life insurance. Go ahead and set up an irrevocable life insurance trust that owns insurance on the owners of the enterprise, the senior generation. Perhaps it's second to die insurance. And it provides that upon the death of the survivor of the senior generation, the children who are not involved in the business will receive tax-free life insurance proceeds in lieu of receiving an interest in the business. We often as well use life insurance to provide liquidity to the generation that is in the business so that they can buy the senior generation's interest at the time of death and then also provide cash to pay estate taxes.
Yep.
The worst case, yes.
I'm sorry, this is Chris again. I know
yes.
We're not supposed to get too technical on this one.
That's all right.
But is there a rule of thumb on who would pay the premiums for that life insurance?
Well, generally the senior generation will pay that by making gifts to an irrevocable trust.
Okay.
Sometimes that can be handled, however, because the second generation or successors that are involved in the family enterprise can be easily convinced that they'd rather pay insurance premiums to take their siblings out instead of having to pay them 100 cents of the dollar when their parents die to reacquire their stock. So quite often you can go ahead and bonus funds either out to the parents that can make contribution to the irrevocable trust, bonus it out to the generation that is active in the business, or make some other arrangements. So you can use the corporate funds or the corporate cash flow to fund this insurance on an indirect basis and provide for the assets of the business going to the generation that's active, and provide for an alternative asset to go to the members of the family who are not active. One of the things that is sometimes overlooked, because I've been through this three times, is where there's only one irrevocable life insurance trust set up. It owns all of the insurance. The trustee has been instructed, although not required, to use the assets of the irrevocable life insurance trust to buy the stock of the family enterprise or the units of the family limited liability company, etc., therefore passing the cash into the estate to pay the taxes. Well, now you have the family enterprise holding the units, and those units of ownership are going to be passed to members of the family who are not active. The members of the family who are not active will often call the trustee and say, we have no interest in receiving units of the family enterprise because they are of no value to us from an economic standpoint. We would just as soon receive our share of the insurance proceeds. And now the insurance trustee has a conflict and a dilemma. So if you have members of the family who are not active in the family enterprise, perhaps the use of two irrevocable life insurance trusts is appropriate so that you can go ahead and equalize the interests of the family members in the business and the family members not in the business. The other way to look at it, as I've said in this slide, is to go ahead and take a look at other assets, real estate, 401k, IRA, stock portfolio, rental property, etc., that the other members of the family could receive that is not necessarily tied up in the business. If it is the business's real estate, perhaps they can become owners of it, but they would be subject to a lease that protects the member of the family that is, in fact, going to be running the business. So, again, at risk of repeating myself, on this slide I say at the bottom, providing non-involved family members with stock in the enterprise, although good planning to reduce estate taxes, is terribly flawed succession planning in my experience. The next one, and the biggest obstacle, and again, we're trying to give you a practical approach to succession planning as opposed to a technical legal and tax discussion. The biggest obstacle is the parents. And the parents feel obligated to pick one of their children to lead the succession plan and lead the company on a going forward basis. And the problem is parents want to treat all of their children equally. And the parents assume, for some odd God-known reason, that even though their kids never got along when they were kids, they're going to get along fine now that they're adults. Well, I can tell you from experience, if they didn't get along as kids, it's not likely they're going to get along as adults. But be that as it may, one of the things that we have found extremely effective is to involve the successors in the process. I call it bottom-up planning. We start with an interview of the senior generation, including the spouse, because the spouse quite often has a tremendous amount of influence, not necessarily on the day-to-day operation of the business, but on who and how the family members will be treated in the ultimate succession plan. So you need to involve the spouse and get their input. I like to interview the spouse and the primary controlling owner separately, and then perhaps together. But then, before we put together a plan, we want to talk to these successors. Should we open up questions for the 4Ds? Yeah, yes, we can do that. I'm responding to Chris. We can do that, Chris. One of the things we want to do in this particular bottom-up planning is involve the successors. My experience is when you...
The conference has been unmuted.
My experience is if you go to the is there somebody have a question?
I just unmuted folks if they want to chime in with a question.
Okay.
Yep.
Good. If anybody has one, please chime in. Okay. All right. I'll keep going here. My experience is that when the attorney, the accountant, and the senior generation call the successors into the conference room and tell them this is what you're going to do and this is the plan we've put together, it's doomed to failure. because they have not been involved in the process, they've taken no ownership of the process, and they feel like it's being jammed down their throat. It's sort of like the parents saying, do this because I told you to do it when they were kids. So they don't respond well to that. What I have found is much, much more effective is to go ahead and sit down with the successors and get them to address the issues that arise among successors in any family enterprise. How are they going to compensate each other? How are they going to make decisions about who has authority over hiring and firing, the strategic direction of the company, and what their individual daily responsibilities will be? How do they go ahead and divide up profits at the end of the year? Will there be an equity component, or is it strictly based on performance? If there is one individual who is going to be designated as the president, for example, I've used this quite effectively in planning, then the president's salary will be X. And then the vice president or other members of the family's salary will be perhaps 80% of X, or 75% of X, or 60% of X. What that requires then is that when the president decides to give him or herself a raise, they have to give their siblings a raise as well. So it eliminates some of the acrimony if individuals plan without input from the other. What we also do, for example, is we write a close corporation agreement or an operating agreement that provides that the president or the primary designee is going to have 2 votes. And the other members of the family, let's say there's 2 others, will have 1 vote each. Now obviously what that means is the 2 members of the family who have 1 vote each cannot direct the control of the company. But the senior second generation successor only has 2 votes, so they can't direct strategic decisions without the approval of one of their siblings. So it forces some attempt at consensus and understanding. And that's very important in a family enterprise, because the family enterprise itself will not succeed if the members of the second generation can't agree. Now, if you come to a workable plan with the successors, then that workable plan with the successors will allow them to go back to the senior generation, their parents generally, and say, this is what we can live with. And then the parents can endorse that plan. And that's a much easier approach for the parents to endorse the plan their children have come up with than to pick between their children and try to dictate to their children how they're going to run the business. In addition, this is a very effective way for the senior generation to find out, can the successors get along, operate this business successfully, etc., or are they going to implode? That's extremely important when you consider the first W. If the business does not succeed, then the business is not going to be able to pay the senior generation what they require from the enterprise. So to go ahead and put the successors in place while the senior generation is still in control and see how they work together is a very, very effective way of doing succession planning. Chris has suggested, and I think it's a great idea, before I go on to the next topic in this discussion of a practical approach, which is what I call the 4 Ds. Can I address any questions that anyone has had?
The conference has been unmuted.
Because I've been talking for about a half an hour now.
I just want to let folks know that I've unmuted all the lines, so what you say can be heard. And is there any questions?
This is what usually happens, so don't feel bad about it. Okay. If there are questions or things that occur to you, please go ahead and speak up. I'll take you now through what I call the 4 Ds, and the 4 Ds I submit impact virtually every relationship you are ever going to have, whether it be a personal relationship or a business relationship. And you need to learn to address the 4 Ds to have an effective plan, whether it be personal or business. And it's extremely important when you talk about putting in place a succession plan. And again, I've been talking now for almost 30 minutes, and I have not talked much about taxes or legal issues. I've talked about practical business issues in the interpersonal relationships of families and owners of enterprises. The first D is death. Whether it be your spouse, your significant other, your sibling, your parents, your business partner, somebody's going to die. And when they die, what does it trigger? Does it trigger a requirement to sell? Must they sell their interest in the enterprise, or can their interest in the enterprise be passed on to the next generation of their family? That obviously is a threshold question. If in fact they are required to sell, and if in fact there is not sufficient assets to pay the family off in cash at the time of an owner's death, then you're probably required to make installment payments in order to keep the enterprise healthy. The first W and the second W. What does the senior generation require? What can the business afford? Therefore, should the survivors, the surviving spouse, the children, the trustee, the accountants for the family have access to the books and records? Should there be restrictions placed on the surviving owner's ability to take money out of the company until they have paid off the deceased generation's share? Should there be a limitation on their amount to bonus themselves money? Should there be a limitation on their ability to reorganize the capital of the company? Should there be some requirement that they pay off the deceased generation's shares before they allow a change in control of the enterprise? In other words, sell it. That's particularly germane if, in fact, there is no insurance or not adequate insurance to pay off a deceased generation's interest in the enterprise. Now, it gets even more complicated if upon death the individual who is an owner of the enterprise really does not want his or her family to have to sell their interest in the enterprise. They want to pass it on to their children. That can be very complicated because as you add more family members to any enterprise, it's difficult. And there's an old saying in this business that says that the value of a family enterprise is relative. The more relatives, the less the value. And it's something to take into consideration because you don't want an employer of the family enterprise to become the employer of last resort. And if it is, you're probably not doing the entity a good service, and you're going to have a difficult time maintaining the second W. What can the business afford? If you can buy insurance, it is clearly a very effective mechanism to take care of the death equation. It would require the deceased owner's estate to sell the stock or the units of membership interest to the surviving members or to the entity, either a cross-purchase agreement or a stock redemption agreement, for example. And under Section 2703 of the Internal Revenue Code, if there are family members involved as the successors, then you have to use a method of valuation for that interest that is recognized under Section 2703 as a legitimate way to value that type of enterprise. And what that means is a formula or an appraisal method. Formulas I have used, I'm always cautious with formulas. Formulas are very effective when they're first dreamt up and put into the agreement. The trouble is the enterprise itself can change over time, and therefore the formula, unless it's challenged on a regular basis, may be obsolete when death does occur and there's a triggering of the buyout. The appraisal method we usually use is that if there's not been a determination of value within 2 years, an appraisal for example, and there's a triggering event, a death, then the estate of the deceased owner pays for an appraisal. The survivors can obviously accept that appraisal, and that becomes the buyout price. If the survivors think that that appraisal is obviously too high, they then pay for an appraisal of their own. If those two appraisals are within 20% of each other, then we take the mean, and that becomes the value. If the two appraisals are more than 20% apart, then we have the two appraisers pick a third, and that becomes the value. And we also require that if the two appraisers for some reason are instructed never to agree on a third appraiser, then within 10 business days we have the dean of the, for example, the Weatherhead School of Business, pick the appraiser so that that process cannot be slowed down. It sounds cumbersome. It's not. It's really quite effective and does force people to be reasonable because they can't manipulate the process. The second D is disability. You and I are 6 times more likely, according to the actuaries, to become disabled and not be able to complete our work before we reach age 65 than we are to die. So therefore, disability has to be addressed in any family enterprise or succession planning arrangement because someone is likely, if there's multiple owners, to be unable to complete their tenure at the enterprise. And what does that trigger? Does it trigger a requirement that they sell, or can they continue to own an interest? I submit to you that's a function of what the enterprise is. If the enterprise owns rental real estate, And a rental manager, real estate manager, or a real estate firm can be hired to run these companies, collect the rent, do the maintenance, etc. Perhaps disability really has no impact on one's ownership interest. If, however, you're doing a succession plan or a buy-sell arrangement, for example, for a professional services firm, an accounting firm, a law firm, an engineering firm, etc., the individual's disability, which prevents him or her from being able to practice their chosen profession, can have a significant impact upon the enterprise, and should it trigger a buyout. If it does trigger a buyout, how is that buyout funded? Because of the 6 times more likely to occur than death, obviously disability insurance is significantly more expensive on a per $1,000 basis than is life insurance. The presumption often is that you will be able to fund the disability from the compensation of the disabled partner, which is probably true, but you also have to take into consideration when doing this type of planning, will the disabled partner have to be replaced? Now, presumably they can be replaced, but not at a price as high as that you are paying the disabled partner. And so you will have some cash flow. So the question becomes, over what period? And perhaps more importantly, are the disability payments then ultimately credited toward a buyout of that disabled member's interest? Or are a portion of these disability payments credited toward an ultimate buyout of that disabled partner's interest? We also have had disputes, I remember one with some physicians, over whether or not a partner really is disabled. So we use the same mechanism. In this particular case, we have the entity pay for a physical of the allegedly disabled partner. If that doctor determines that he or she is disabled and the allegedly disabled partner disagrees, they can have a physical done by a doctor of their choice. If the 2 doctors are in disagreement, then the 2 doctors will have to pick a third, or again, we default to the Case Western Reserve Dean of the Medical School to pick a physician to make that decision. Obviously, there's nuances there because someone may be partially disabled, but they can still work. You also have the Americans with Disabilities Act, which says that you must make a reasonable accommodation, etc. So disability is something that has to be addressed, and the practical aspects is, how does it apply to the specific business your client is involved in? The third of the 4 Ds.
Jim?
Yes.
We have a question about the disability insurance. You said it was more expensive.
Yes.
And the question is it harder? Is it subsequently harder to get rather than regular life insurance? And I'm assuming they mean for something like maybe a pre-existing condition.
Yes. The answer to that is yes. If someone has, for example, a pre-existing condition, they may get disability insurance, but it will not. But there'll be an exclusion for the pre-existing condition. Now, what you can also do, however, is group disability insurance for all the employees of an entity is often available without proof of insurability if it's done early enough in the equation. So that is something to consider. And what we encourage is at least partial funding of the disability risk with insurance without necessarily 100% funding. The life insurance risk is often insured to 100 cents on the dollar. The disability insurance, from a practical cost standpoint, is only insured up to a reasonable, what clients often call their premium tolerance level, how much they feel they can do.
Okay.
And certainly, and obviously, the longer you wait, I'm 59 years old, and if you're trying to buy disability insurance when you're 59 years old, it's extremely expensive. If you buy it when you're 39 years old, it's quite reasonable. So it's also a function of age and the health of the individual. And then you have to consider, too, how much waiting period is involved. Does the individual have significant other personal assets? Will the company pay their salary for 90 days or 6 months, so therefore the disability doesn't kick in until that exclusion period is up? It's just like a large deductible. It drives the cost of the insurance down substantially. The third of the 4 Ds is departure. And departure is someone gets burned out. Someone decides they want to just retire. They are done, whatever. This can be problematic, particularly if the individuals who started the enterprise felt that we needed to stay together for at least 30 years or 25 years or 20 years, and somebody wants to get out after 10. If they want to get out after 10, is in fact there going to be a discount of their interest? The discount of the interest, for example, may say if you leave 5 years early, then we're going to discount your interest by 20%. If you stick around, there will be no discount. If you leave early, then we're going to go ahead, instead of paying you out over 5 years, which is what the agreement calls for, we're going to pay you out over 10 years because we didn't expect to have to dip into the cash flow of the enterprise so early to take out owner out. And perhaps it's going to go ahead and provide that the ultimate payout will bear an interest rate that is perhaps less than market, and clearly we want to non-compete if someone's going to leave. And I submit that if someone does leave, you want to buy them out because a minority owner of an enterprise who's not active in the enterprise only represents an opportunity for acrimony, which is in no one's best interest. So you want to go ahead and force that person out. The question becomes, how do you arrive at value? And once you've arrived at value, is there some reduction of that value? I want to move on because I know, Chris, we're getting reasonably close to taking up too much time here. The fourth D is discord. I used to use the term divorce, but people took it too literally. Obviously, a divorce can impact a closely held enterprise, but discord among the owners of that enterprise occurs with regularity. I tell clients that if there's no discord, that means one of you is not thinking or one of you is probably unnecessary. So there has to be some discord in an enterprise. There's two schools of thought on how to handle discord. One is not to have an exit strategy or a solution to discord. Force the parties to reach a consensus by working together because they don't have an option. The other, and I think perhaps more effective method, is to use puts and calls and perhaps the push-pull mechanism. For a put and a call and a push-pull mechanism to work, however, and I'll explain those to you very briefly, you must agree in the agreement, in writing, to the form of the buyout. For example, the buyout will be over 5 years. The buyout will be at the applicable federal rate. The buyout will require the departing owner not to compete for the 3 or 5 year period of the organization. The buyout will require the surviving members or the remaining members of the organization to personally guarantee the obligations to the departing or bought out owner. Now, if you have those things agreed to in advance, then the only thing left is, what's the value? What's the price? Well, with a put and a call, if there is a formula price or an appraisal price, you can then go ahead and say, if I am putting my stock, if I'm the one who wants out for whatever reason because I can't get along with my partner, I'm exercising my put, I am forcing my partner to buy me out. So maybe the 5-year buyout becomes 10 years. Maybe the applicable federal rate becomes the applicable federal rate less 200 basis points. So if it's 6, maybe it's 4%. And if the value is $2 million, perhaps I have to take a 25% discount for the $2 million because I am forcing that individual to buy me out before that individual or the entity is ready to or desires to. Call works just the opposite. The call is where I want to buy a partner out or a member of my LLC out because I think they're interfering with the success of the enterprise. Therefore, I must pay them perhaps instead of over 5 years, I may have to pay them over 3. Instead of paying them the applicable federal rate, I may have to pay them the applicable federal rate plus 200 basis points, so it goes from 6 to 8%. I must give them a restricted non-compete, maybe a shorter non-compete. So, and in addition, I may have to pay them a 25% premium to force them out because I am forcing them out of the enterprise. What the push-pull does, and which is why it's the most effective of all the methods, it's like a put and a call, but with a twist. The push-pull method says that we have an arrangement that says the transaction will be 5 years. We have what the interest rate will be. We know that it will be a non-compete, et cetera. The only thing we haven't agreed on is the price. So I go to my owner and I say, I am willing to buy you out over 5 years at $2 million at the applicable federal rate with a non-compete for 5 years. Now, the person that I have approached, since I have made the first move, has the right to accept my terms as a seller or has the right to accept my terms as the buyer. Why that works? Because the dispute is always over the value. When you use a push-pull mechanism, you don't know as the person making the offer whether you're going to be selling at that price or buying at that price. So therefore, it has a deterrent or a process of making the valuation reasonable. Because if you're selling, obviously you want to get as much as you can, but if you're buying, you want to be able to afford it. So it can be by far the most effective method of creating a solution to discord. Finally, and I'm just about there, I think in terms of time, Chris, is management succession. Management succession is constantly overlooked. Chris, did you want to tell me something?
Nope, no.
Okay. Management succession is often overlooked as part of the succession planning process. Most of what we've been talking about today so far has been ownership succession, how we pass that on. And when we talk about bottom-up planning, we are addressing management succession in terms of who will make day-to-day decisions, etc. But if you are a business owner or you represent business owners who don't have a management succession plan in place or an emergency management plan in place, you need to sit down with them and put one in. One of the things I always do with a owner of the company is I ask them what are their 3 key functions. And occasionally, probably half the time, the owner struggles to come up with what their personal 3 essential functions are in the enterprise. And I congratulate them when they tell me that, because that means in my mind they have institutionalized their business, and therefore it operates as an enterprise without their day-to-day involvement and hands-on working. That means they have a business that has value, because it can be sold to a private equity group, it can be sold to the management, it can be sold because the value exists beyond the owner's personal prowess, personal expertise, personal connections, etc. They have institutionalized their business, and once they do that quite often, we also find that they're off the personal guarantees at the bank. The bank is now loaning to the entity, not based on the credibility of the owners. So that's good. Now, if there are key functions that the owner addresses, then you must discuss with the owner what would happen if they died, or what would happen if they became disabled, and what would they recommend to their family. Should they sell the business? Should they replace the deceased or disabled owner with professional management? Is the existing management sufficient to carry on the enterprise? Management succession is absolutely essential to maintain the value of an enterprise. If it's not in place and the owner does become disabled or does die prematurely, suddenly, then the value of the enterprise can drop like a rock. And then you could end up having an estate sale, and that's where you get the charlatans in who try to buy it at a bargain price. So part of succession planning must involve who is going to run the company during any period of emergency, and theoretically, who would run the company on a long-term basis. I've got many owners who like to hold on to their companies, but they don't want to be there on a day-to-day basis. They run them remotely. That's okay. But management succession is essential to the succession planning process. I've been talking for 50 minutes, Chris. We've covered the slides. I hope this was useful to those of you who are on the line in terms of an introduction to how succession planning can be structured and how you can use it in your practices or in your enterprises to get to a good result. And if there's questions, I would be thrilled to answer them.
Sounds great. Jim, I am going to open up the phone lines to everybody here.
All right.
Unmute all, so just folks remember that
the conference has been unmuted.
Heard by everyone in the group. And I think it's just done it. Jim, if folks want to get in touch with you, how would they do that?
My email is jawesome, that's A as in apple, U as in up, S as in Susan and Sam, EM as in Edward and Mary, at Weston Hurd, that's WESTONHURD.com. And my direct dial number is 216-687-3358.
All right, sounds great. We have questions.
Yeah, I had one. At the end of step 3, there was a comment. If you could comment on the last first out, who does it benefit?
The bottom-up planning?
Yeah.
Is that your question is?
The end of step 3.
Okay, the end of step 3, providing non-involved family members with stock.
Sorry, we're kind of getting a delay in between the questions and not hearing. Was it the providing non-involved family members with stock?
No. As far as inventory, last in, first out, who does it benefit?
Oh, the last in, first out. Okay, you're talking about the 4Ds.
Yeah.
Yeah. Okay. Well, what I'm concerned about there is if someone wants to go ahead and be the first person out before the company is going sideways, you don't want to give them an incentive to be the first person out. You want to give these people an incentive to work together for a minimum period of time. And maybe that's these two people thought they'd worked together for 20 years, and the one guy says, things are great, the business is healthy right now, I want to be paid now because I don't want to take the risk over the next 10 years. It often is the case with a business situation where one of the owners is, for example, 65 and one of the owners is 45. Obviously the one that's 65 probably is going to go out first. Can the enterprise afford to buy that person out? Can the enterprise afford to provide them with at first W what they need to being the first person out? And does the person then who buys them out get saddled with a lot of debt that they can't then expand the business, take care of the capital requirements of the business, etc.? So if somebody wants to, quote, get out early, we try to make that less attractive by making them take a discount, by making them take their payments over a longer period of time, and perhaps with a lower interest rate, so that you aren't motivated to be the first person out.
Does that answer the question? Do we have any additional questions? All right. Well, I think at this point I want to thank Jim for an excellent presentation. Remind folks that this webinar will be archived on our website probably within the next day or two, later today or early tomorrow, so you can rewatch it if you need to catch up something that you might not have got the first time around. And remind that we have another series of 2 webinars coming in 2 weeks, and the information on that is available on our website. And thanks, Jim, and thanks to the folks for coming out.
Folks, I hope it was useful to you. I hope you enjoyed it, and have a good rest of your day. Enjoy your Memorial Day weekend.
Thank you.